Fellow students, I address you as fellow students in the hope and belief that I am still a student. I have not stopped learning. Sri Ramakrishna Paramahamsa said, as long as I live, so long do I learn. I think this should be the spirit which should animate all our life and work. And to recall Sir Jamshedji Kanga, one of our tallest lawyers, physically and metaphorically. He was 6 feet 4 inches tall. So he was the senior of Sirvai and Kanga. At 90 plus said, I'm still learning the law. So that, I think, sums up what your attitude and my attitude should be when we approach the study of law. I consider myself privileged to have this opportunity to share with you a few thoughts on learning the law. I speak to you not so much to give you any tidbits, but I believe that whatever I say may help to inspire you to aspire for greater things in law and in life. Please don't feel afraid if I mention big names. You will hear of these names as you go along in your study of law. William Blackstone, that's a very renowned name. Blackstone's commentaries on the English law. William Blackstone, at the opening of the Vinerian lecture in 1758, said, I think it is an undeniable position that a competent knowledge of the laws of the society in which we live is the proper accomplishment of every gentleman and scholar, a highly useful, I had almost said, essential part of liberal and polite education. Learning the law deepens one's insight and knowledge as science does, and broadens our outlook and vision as does art. Learning law is thus both an art and a science. What is law? Law eludes a precise definition. And as Max Radin, the great political philosopher, remarked, those of us who have learned humility have given up the attempt to define law. Law may be said to embody a code of conduct and self-discipline, which a nation speaking through its elected representatives adopts for itself and enforces through the machinery of the judiciary. Law, it is rightly said, is the cement of society and an essential medium of change. Civilization involves the subjection of force to reason. The agency of such subjection is the law. In fact, to refer to you two very great names in law, Justice Cardoso and Judge Learned Hand, Cardoso defined law as the medium, the instrument by which society represses conduct which awakens fear of such intensity as to make toleration impossible. And Judge Learned Hand said, law is no more than the formal expression of the tolerable compromise we call justice, without which the rule of tooth and claw would prevail. Now, with knowledge of law increases one's understanding of public affairs, its study promotes accuracy, facility in argument, and skill in interpreting the written word, as well as some understanding of social values. Law is not just a set of rules. It is something more. It is an underlying philosophy and seeks to represent a synthesis of the urges and aspirations of the people and a quest for what is good. Its aim is the greater good of all. Law is perhaps the only integrating force in pluralist societies, and therefore a cultivated respect for law and its institutions, and faith that people live under an adequate legal system are crucial and imperative for preserving the fabric of society and holding the nation together. Law lives ultimately not in the books, but with the profession, and even more in the minds and hearts of the people, in their attitude and consciousness. Now, legal education, learning the law, is a matter of vital importance, both for the practice of law as a profession and also for the community's welfare in general. It is no doubt a vocational training for legal practice, but is equally a means of fostering intellectual discipline for evolving a well-ordered human society. And I would lay greater emphasis on this, fostering intellectual discipline. Sir Owen Dixon, a very distinguished former Chief Justice of Australia, once said, "There is often a professional protest against the time spent in universities on the theoretical at the expense of the practical. There is thus an inversion of functions. The dividing line between academical and professional is improperly drawn, and the student sometimes loses the one chance he might ever have of learning how philosophical are the basic principles of science he is about to apply as an art." So we must all remember that law is both a science and an art. A sense of legal history is indispensable for understanding the interrelationship of all institutions and disciplines. Science gives precision and sharpness. Arts lend liberality and breadth to legal discourse. While the study of science and technology sharpens the mind and intellect, it is arts and humanities which broaden the vision and enable you to understand and appreciate the finer aspects of man and nature. Humanities, history, poetry, philosophy, and the like, apart from enriching the individual, are essential for performing one's duties in a democratic society. Your judgment can be ripened only by an awareness of the course of human life, its failures and successes notwithstanding, its indomitable will to endure. And for this, our horizon has to be widened and outlook clarified by knowledge of what men have striven to do, how their hopes and fears have been realized. There is no substitute for an open mind enriched by reading. As Ruskin said, art is the conveyance of the significance of man's inner attitude towards everything. Over the ages, mankind has built a treasure house of knowledge and art, of thoughts that wander through eternity, and of art, which is the wide world's memory of things. The communication of the dead, it is said, is tongued with a fire beyond the language of the living. And as Walter Scott very rightly and meaningfully emphasized, a lawyer without history or literature is a mechanic, a mere mason. If he possesses some knowledge of these, he may venture to call himself an architect. I'm sure all of you, as you come into the law, would aspire to be architects and not mere masons and carpenters. I would very respectfully commend to you to read every day, apart from law, which of course you would, to pass the exam and otherwise, a few pages of a classic. That is a great education in itself. And even a few pages a day, over the years, you can imagine how much you would have read and how much it would enrich you. Now, what are the qualities demanded of an accomplished man of law? It is said sagacity, insight, acuteness, courtesy, dignity, wisdom, uprightness. Lawyers must be equipped with significant learning, learning which is more than mere accumulation of facts, learning which makes a difference in the individual's behavior and attitude towards society as a whole. It is equipping a lawyer with significant learning that legal education has to address itself and play its vital role. And I'm sure in CMR, as you step in, you would be provided with this kind of significant learning. Legal education should be broad-based and not confined to mere vocational aims. There should be a proper amalgam and synthesis of academic scholarship and professional requirement. The training of the lawyers should be intensified, both for professional purposes as also as an academic discipline. Unfortunately, to deviate a bit, what is lacking in India today is academic discipline. We have very successful practitioners, but not many who are academically inclined and who pursue law and its study as a discipline and a theory. Now, I would like to tell you something very profound. In response to a young boy's letter to Justice Frankfurter in 1954, when Frankfurter was a sitting judge of the US Supreme Court, a young boy wrote to him what he would advise the youngster if he were to prepare for law. And this is what he wrote. Please mark these words. No one can be a truly competent lawyer unless he is a cultivated man. If I were you, I would forget all about any technical preparation for the law. The best way to prepare for law is to come to the study of law as a well-read person. Thus alone can you acquire the capacity to use language on paper and in speech, and with the habits of clear thinking, which only a truly liberal education can give. No less important for a lawyer is the cultivation of the imaginative faculties by reading poetry, seeing great paintings in the original or their reproductions, and listening to great music. Stock your mind with the deposit of much good reading and wisdom, and deepen your feelings by experiencing vicariously, as much as possible, the wonderful mysteries of the universe, and forget all about your future career. I think very telling, very profound. And how broad and incisive legal education is to be is brought out in these well-known words of Justice Cardoso, uttered more than a century ago. He said, the barest rudiments of law suffice to give the accolade of those days the privilege to kiss the hem of a flowing and unspotted robe. But it is otherwise in this year of grace. This was said 100 years ago, so it is much more otherwise in the 21st century. But it is otherwise in this year of grace. Our Lady of the Common Law, I say it with the humility that is due from an old and faithful servant, has become insatiable in her demands. Not law alone, but almost every branch of human knowledge has been brought within her ken, and so within the range of sacrifice expected of her votaries. Those who would earn her best rewards must make their knowledge as deep as the science and as broad and universal as the culture of their day. She will not be satisfied with anything less. This is a tall demand, is a challenge to all of us. No branch of the law, rather, no branch of learning is useless in the life of a lawyer. A clear grasp of the facts of each case and the legal principles is the essential prerequisite for mastery of the law. The reason of the law is its life. He who knoweth not the reason, knoweth not the law. Legal education should be thought-provoking, and I would say it should set your imagination on fire. There is no better way of exercising the imagination than the study of law. Winston Churchill rightly observed that no one would know everything, but one should know where to find it. Samuel Johnson said, half the knowledge consists in knowing the books. Thus the importance of libraries and the sources from where you can know. Now, first-hand reading of the original material is imperative. It is essential to read and be familiar with the classics in every subject. Anything less will not suffice. It may suffice for us to pass our exams and get the degree, but it will not suffice to be a lawyer in the real sense. Facility in such things may seem a small matter, but much toil may be wasted and precious time lost for want of it. To the working lawyer, these things are the tools of his trade. He depends on them for that whole region of potential knowledge, which must bear a proportion to the actual. A law student and a lawyer must know how to find the material and equally how to use it. Because, application of principles is something that you have to, the skill has to be developed. Whether you're dealing with statutes or judgments, textbooks or commentaries, or law journals on different subjects. You must familiarize yourself with technical abbreviations, technical expressions, and legal abbreviations. You must have at least a passing acquaintance with the law reports and law reporting. And I would commend, please don't be satisfied with reading the head notes when you're reading a case. They are just enough to give you an introduction, like you open the door. But many times there are printers' devils. I know quite a few cases where the head note says just the opposite of what the judgment says. And therefore, you should always read the judgment as a whole, the facts and the law. Now, reading a good, well-crafted judgment in whichever subject will help widen one's horizon, broaden one's outlook, suggest new lines of approach to legal issues, cultivate the art of practicing and perceiving distinctions, and furnish with a stock of forceful vocabulary. I would repeat to you the advice that Justice Hidayatullah gave me when I was a student. Please make it a point to read at least one Privy Council judgment every day. You have the whole set of Indian appeals, and Privy Council judgments, unlike judgments these days, when it is rather jocularly and vulgarly said, there is a lot of diarrhea now in judgment writing. Privy Council judgments were short and crisp, hardly more than 2 or 3 pages. They equip you with the idea and with the vocabulary. Therefore, please make it a habit to read at least one Privy Council judgment a day. It will go a long way in molding you. Now, apart from serious legal reading, one could profit by devoting time to reading literature touching upon law and the works that are set out in the background in which the lawyer lives. It would be rewarding to read biographies. It is absolutely necessary. And autobiographies of men of law. Every student should study the lives of great lawyers who shed luster on the profession. That would be both educative and inspiring, and would produce in everyone a yearning for what is good and great. Now, words are the lawyer's tools of the trade. Language is the vehicle of thought. It is therefore very essential that you cultivate a command over the spoken and the written word. There should be no clumsiness in expression. It should be marked by clarity and precision, combined with elegance. Nothing could be a better equipment. You would notice as you go along that there is a marked difference between how a lawyer expresses an idea and a layman. The ideas may be the same, have the same profundity. We can't dispute that. But the manner of expression, the precision that comes with one's training makes all the difference. In fact, Lord Denning had advised that you should begin and end the day reading poetry. Why? Because poetry gives you precision. A poet expresses in a couple of stanzas what takes pages of prose. You need ideas, words will flow. You should make the language of the classics and the judgments your own. You must familiarize yourself with the legal jargon. To quote Joseph Story, I must tell you, was one of the earliest judges of the American Supreme Court. I think he went to the Supreme Court. He was perhaps the youngest to sit on the Supreme Court. He went to the bench, I think, at the age of 39 to the Supreme Court and stayed there for about 30 plus years. It is said that he was a companion judge of Chief Justice John Marshall, the great chief. And while Marshall formed the judgment in his head, how to give expression to it, how to base it on theory, that job fell to Justice Joseph Story, who was not only a lawyer and a judge, but an eminent jurist. In fact, for generations, you had the scholar's seat in the US Supreme Court. You had Joseph Story. Then years later, you had Justice Gray, who was succeeded by Justice Holmes, who was succeeded by Justice Cardoso, and who was succeeded by Justice Frankfurter. I think with Frankfurter's retirement in 1963, a scholar's seat on the US Supreme Court bench came to an end. Now, Joseph Story tells us this: law is a jealous mistress and requires a long and constant courtship. It's not to be won by trifling favors, but by lavish homage. And that's why Lord Eldon, one of the great Lord Chancellors, advised that a lawyer should live like a hermit and work like a horse. I recall Phil Nariman's advice to me when I was a student. There is only one thing which I would tell you, he said. Read, read, and read. Read everything under the sun. So one has to read widely subjects apart from the law to avoid the grave danger of losing in course of time common sense and a sense of reality. A lawyer's education, and when we say lawyer, it definitely includes judges. Lawyer is a generic term. Whether you're a practitioner, you're a judge, you're a professor, you're a corporate man, a lawyer is a generic term. A lawyer's education never ceases. It continues. And therefore, to perform one's duties as a lawyer best, you have always to be a thorough and a continuing student. So there is an advice which Daftari gave. Of course, it may be a little too early now. You're just entering the law, but I think you can keep this in mind. Is an advice that Daftari gave to Phil Nariman. He said, Philly, it's more important to think of a case rather than to read the brief. Reading is, of course, necessary, but more important is you think of it. Then something comes, it happens. You must know law with clarity and with precision. that is science. But you must know its subtleties and the charm and persuasiveness of presentation. That is an art. And that is why we say that law is both a science and an art. Now, talking of scholarship, I think I can do no better than place before you some extraordinary examples. We can only wish we measure up to them, at least in some measure. Ashutosh Mukherjee, the legendary judges. To tell of Sir Ashutosh, in those days, he was a judge at the Calcutta High Court between 1904 and 1924. His personal library had 1 lakh volumes. He had the law reports in his personal library from across the globe, including state courts of the United States. His judgments covered the entire spectrum of law. He examined comprehensively and laid down unequivocally the contours and nuances. The thoroughness of his efforts in every matter compelled a colleague to ask Sir Ashutosh as to how he could always deal with cases in that manner. And in typical fashion, he replied that he would not be there if he could not discharge his functions in such fashion. So that's the kind of involvement, that's the kind of hard work that goes with a lawyer's life. So Aladi Krishnaswamy Iyer, a former Advocate General of Madras and one of the principal architects of our Constitution, served the goddess of law with single-minded devotion. The more complicated a case, the greater the facility with which he resolved the complications. He delved into the past, disinterred the dim beginnings of a given legal doctrine, traced its development through the centuries, and distilled the essence of it, which he presented to the court with confidence. In those days, when constitutional law was not a subject of practice in our courts, Sir Aladi was not only familiar, but absolutely thorough in constitutional law and comparative constitutional law in various jurisdictions. Vishwanath Shastri, a very celebrated lawyer, was arguing before a bench in the Supreme Court. Gajendra Gatkar, Subbarao, and Bachawat, all 3 eminent judges. As Vishwanath Shastri was arguing, Justice Bachawat interrupted him, saying, "Mr. Shastri, is it not true that the position that you're arguing for is covered against you by a judgment of the Privy Council in such and such a case?" Vishwanath Shastri paused for a moment and said, "Precisely so, my lord, but that is the only judgment of the Privy Council which has been adversely commented upon in Halsbury's Laws of England, volume so-and-so at page so-and-so." So this was the kind of equipment that both the judges and the lawyers had. One has to bear in mind the message of Sarat Chandra Bose that professional success cannot be a mechanical pursuit for money, and that nothing would be more tragic if the man lost himself, his mind, and life in the pursuit of mere wealth. Never stoop to conquer or climb by unworthy means. The arms that a lawyer wields has to be those of a warrior, never an assassin. In the learning and practice of law, as in any other walk of life, one learns by watching and by example, both what should be done and what should not be done. how to do it and how not to do it. This is what you will pick up as you go along. There is this incident of a great professor at the Columbia Law School, Professor Walter Gelhorn. As a youngster, he was a law clerk to Justice Brandeis. After he finished his term, he had the choice of either entering the Columbia Law School as a teacher or joining a law firm at the famous Wall Street of New York. On being asked by Justice Brandeis, the young lawyer indicated his preference to join the law firm, which would bring him great returns and with which he could lead an independent life. That was his perception. The great judge then made a profound remark. If independent life was his goal, then he ought to know that independence comes not from the amount one earns, but from how one spends whatever he earns. That is from the kind of life one leads. It changed Gelhorn's preference. He took to teaching. The rest is history. With great contentment and a sense of pride, he told generations of his students that he never ever regretted that decision. Now, talking of learning and scholarship, there is nothing more satisfying and ennobling than learning for its own sake. It's a different thing when you learn, try to understand something because you have a case. That is all right. It is absolutely necessary. But learning for its own sake gives you the greatest amount of satisfaction and joy. And it pays dividends later, there's no doubt. The opportunity to apply it will come, and the scholarship acquired will be handy. The greatness and benefit of acquiring knowledge for its own sake is best illustrated by an incident in the life of Durgadas Basu, the great commentator. It happened long ago, maybe more than 50 years ago in the Calcutta High Court. There was a division bench of Justice A.N. Ray, who later became the Chief Justice of India, and Justice Durgadas Basu. They had heard a matter, reserved judgment, and Justice Ray, the senior judge, read out his prepared judgment. After he finished, Basu called the stenographer and dictated an extempore judgment referring to all the relevant cases and authorities that were required. After the court rose, Justice Ray embraced Basu and said, "What is this? It took me weeks to prepare, but you just came out with the judgment in no time." And then Basu made a very profound, significant statement. He said, "Brother, you read the law for this case. I have not read anything for this case. I have been reading all my life. I only applied it." That brings home to us the importance of learning all one's life, learning law for its own sake. You should remember, if you decide to rise to professional eminence, that law is both an art and a science, and that success, whether at the bar or on the bench, will depend on the clearness with which you understand the principles of the science and the readiness with which you will pass through a complicated mass of facts in the mind, in the midst of animated addresses, taking as it were by intuition each fact. The study of law, it is rightly said, is in a higher sense the study of philosophy and social life. The art you have to practice is one of the noblest. The object is the protection of human interests in all relations of life. I would quote to you what John Stuart Mill said in his convocation address to the University of St. Andrews in 1867. Those who know how to employ opportunities will often find that they can create them. So what we achieve depends less on the amount of time we possess than on the use we make of our time. I do not attempt to instigate you by the prospect of direct rewards, either earthly or heavenly. The less we think of being rewarded in either way, the better for us. But there is one reward which will not fail you and which may be called disinterested, because it is not a consequence but is inherent in the very fact of deserving it. The deeper and more varied interest you will feel in life, which will give it tenfold its value, and the value will last to the end. All merely personal objects grow less valuable as we advance in life. This not only endures, but increases. To the same effect is what Dr. Ashbihari Ghosh said in concluding his Tagore Law lectures in 1876, where he said that a higher reward awaits those who pursue learning for its own sake. You should not fall into the habit of prizing low and gross ideals without suffering deterioration in one's intellectual and moral fiber. It's therefore advisable, he said, to labor and to wait. And if one is ever tempted to join in the fierce hunt after the vulgar prizes of the world, it should be remembered that after all, the successful man, as he is called, looks sleek and is not unfrequently a poor player that struts and frets his hour upon the stage and is then heard no more. Now, as you enter the study of law, you should remember that law is a profession. And it's called a noble profession. It is not a commercial venture. Roscoe Pond observed, historically, there are three ideas in a profession: organization, learning, and a spirit of public service. These are essential. The remaining idea, namely gaining a livelihood, is incidental. We need to remind ourselves of these basic truths. We live in an age of what Dr. Professor Upendra Bakshi called massacre of ancestors, which is considered a kind of a virtue today. But collective amnesia of what happened in the past is not a value. Without living in the past, its recall is important, for it necessarily presages a future. We cannot overlook or forget the enduring relevance of the past and its torchbearers. And I must tell you that today, 5th November 2020, happens to be the 150th birth anniversary of one of our tallest leaders, national leaders, and of one of our very great lawyers, Deshbandhu Chittaranjan Das, who was born this day in 1870. He rose to be an extraordinary gifted lawyer who, at the height of his very lucrative practice, gave up everything, including his house, to the nation to plunge himself in the national movement. He passed away well before his time in 1925 at the age of, he was not even 55. But in that short span, if we may say, left his indelible imprint on men and matters and our national life. It's an occasion for us to salute his memory today and record our gratitude for such an extraordinary life. One cannot forget that character is all important as we go along. Character is integrity plus altruism. Fame is a vapor, popularity an accident. Riches take wings. Those who cheer you today will curse you tomorrow. Only one thing endures, and that is character. And you will remember as you go along that all embellishments, all paraphernalia mean nothing. Only character and competence ultimately matters. This is the ideal, and I'm quite aware that in today's world, it's a difficult thing to achieve. But then, as they say, you must learn to hold your hands to the stars that you may fall on the treetops. But if your sights are so low, then where do we fall? We may fall into the gutters and nothing more. That can never be. You should not allow that. Always keep with you as you go along your life the best that a university education can offer. The company of great thoughts, the inspiration of great ideals, the example of great achievements, the consolation of great failures. So much so that the buffets of circumstance and the caprice of fortune will leave you untouched and definitely unswayed. There is more to life than success and more to success than money. What is success after all? It means many things to different people. It's difficult to define. But believe me, success is not just making money. As Disraeli said, money is not the measure of man. Many times it shows how small he is. Now, to quote Emerson, to leave the world a bit better, whether by a healthy child or a garden patch or a redeemed social condition, to know that even one life has breathed easier because you lived, that is to have succeeded. And I may add that you have helped, if you have helped to nourish and strengthen institutions and systems, spread knowledge and increase wisdom, that is success. And this is what one should always aspire for. When it comes to the end of the day, we should be able to say that while we came into law to do well, we stayed in the law to do good. Aspire not just to make a living, but to live a life and make a difference. I do hope that the years that you spent in the law school and beyond will be years of promise and fulfillment in its real and nobler sense. While welcoming you to the study of law, let me wish you the very best in law and in life. Thank you so much for your patience and courtesy.
Thank you so much, sir. It was truly inspiring and thought-provoking. Uh, you have actually taken us through the different aspects of the evolutionary aspects of law. You have touched upon different dimensions and phases of law. Truly inspiring it was. And as a final note as to what sir was saying, it also is very important to each one of us to realize that law is used as a nation to speak to its representatives. And since it is the language, law lives in profession, attitude, and minds of individuals. It is truly inspiring with regard to your understanding and the way you put it to us with regard to the nature of law. So, and also finally, as a final note, Sir suggested three most important aspects for law aspiring individuals are read, read, and read. Now, in the garb of reading, we must not get lost in the secondary sources. because it is the primary sources which matters the most in understanding the law and the principles of law. Thank you so much, sir. Thank you so much. It was truly inspiring. Thank you very much, sir. Thank you for your time.
Thank you. Thank you. Thank you.
All right. As we move forward, you will have an attendance link which will be shared in the chat box. Kindly access the link. There we go. The link is already up. So kindly make use of it and feed in your details for the purpose of attendance. Now,
Anish,
as we move
any
on,
questions?
our next speaker, great, sir. Then, any questions to sir from the participants? Sir has been very kind enough to open the forum to take questions. Any questions at all? Kindly feel free to unmute yourself and then ask questions to sir.
Good morning, sir. This is a parent. This is a
Oh, there we go,
parent
sir.
of a
We have the
child.
first two.
Yeah, yeah. Good
This is a
morning. Good morning.
parent of a child.
Good morning. Good
And
morning.
good morning, sir. And it was absolutely wonderful hearing you.
Thank you. Thank you.
I happen to be a practicing lawyer myself.
Oh,
My
great.
husband is an Air Force officer. We are
Oh.
both here. And you
Nice seeing
actually
you.
spoke of all the absolute principles which I think we've all believed in. And it was wonderful hearing you reiterate them.
Thank
After
you.
a very long time, have I heard such
Oh, thank you. Thank you.
and a very august speaker, sir. Thank you.
Thank you so much. Thank you. Thank you so much.
Thank you so much, ma'am. Anyone else? Yes.
Good morning, sir. I'm Swati.
Good
I
morning.
have one question regarding Privy Council judgment.
Yeah.
So, where we can find those judgments?
Oh, they are all there. You are a law student, I suppose.
Yes, sir. I'm a
Yeah,
law
yeah.
student.
Yeah. You have them in your libraries. They are, reported just like the Supreme Court judgments now. You have from 1914, they are reported in AIR itself, like you have AIR Supreme Court, you have AIR Privy Council. From about 1870, you have the set of what is known as Indian appeals for about 75 years till the independence. Before that, you had the Moore's Indian appeals. You also have cases, reports called Indian cases, but I'm sure your library will have them. There's no difficulty in, private libraries may or may not have the old reports, but institutional libraries definitely would have them. And now, good question. Now with SCC
Can you
online, you even have them on the, what do you call it?
website?
On the website.
Website, sir.
Yes. So it's not very difficult. Yeah. And they're all
Website.
generally short and crisp and to the point. In fact, judges of the olden days would tell you that you must learn how to write judgments like that.
Okay.
All right. I guess, we are done with this session.
Thank you. Thank you
It
so
was
much.
really kind of you even to accept the questions from the participants.
Thank you. Thank you.
Thank you so much, sir. Thank you for your time.
Thank you. Have a nice day.
Good day too, sir. Good day.
Good day.